The first thing I noticed was the white plastic cap, C7. It sat less than a foot from my mother's footstone, bright against the dark Carolina soil. It was March 3rd, 2025. I had come to the family cemetery on Johns Island to repair an old headstone. Instead, I stood there with my tool bag in one hand, staring at a survey marker that had no business being there. My name is Samuel Elijah Greene. I was 60 years old that spring. Most of my working life had been spent repairing old stone, headstones, church steps, brick walls, anything time had started pulling apart. That cemetery was different. My parents were buried there. So were my grandparents, and generations before them. The man who hired the survey crew was my cousin Wade. Wade handled the paperwork for Greene Heritage Land, LLC. I took care of the cemetery itself. That arrangement had worked for years because I trusted him. What I did not know that morning was whether Wade was measuring around the graves or preparing to move them. I set down my tools and followed the line of orange stakes. One stood near my father's grave. Another sat between his stone and my mother's. The line was too straight and too deliberate to be fence work. My phone came out, and I photographed every marker. I left them exactly where they were. Wade understood contracts and regulations better than I did. Pulling up the wrong stake would give him a reason to accuse me of interfering before I even knew what the work was. A truck came through the gate a little after 8. The man who stepped out introduced himself as Daniel Rusk from Harbor Point Surveying. He was polite but careful. "What exactly are you surveying?" I asked. His eyes moved toward the stakes. We were given a relocation map. For a second, I thought I had heard him wrong. A relocation map for what? The burial area. I looked back toward my parents' stones. "Who told you the family agreed to that?" Daniel shifted his weight. "Wade Greene is our contact. We were told the approvals were in place." I told him I owned 30% of the LLC and had never voted to move a grave. Something changed in his face. Not much, but enough. He could not give me company records. He did write down the public file number and the name Palmetto Crest Communities. I thanked him and left before Wade arrived. The next morning, I was standing outside the Charleston County Planning Office when the doors opened. The file was thicker than I expected. Palmetto Crest wanted the full 17.6 acres for a housing development. If every approval went through, the price could reach $8.1 million. That number explained why Wade had kept quiet. It did not explain the map. The cemetery plan showed 26 graves. I had cared for more than 40 marked graves or recognizable burial places with my own hands. I knew where names had faded. I knew where roots had lifted the soil. I knew which families still left flowers. 26 was not an estimate. Someone had made the cemetery smaller on paper. Then I found the consent forms. Most of the names were familiar. A few addresses were old. One page carried Clara Greene's signature, dated February 10, 2025. I read it twice. Clara had been dead since December of 2023. For a while, the hum of the fluorescent lights was the only sound I noticed. I copied every page in the file. Still, I did not call Wade. An accusation made too early would become a clerical mistake. He would tell the family I was upset because the survey line crossed my parents' graves. So I placed Clara's signature on top of the stack and wrote down the date of her death. Before confronting the cousin I had trusted with the keys, I needed one answer. How had a dead woman given him permission to move our family's graves? The file rode home on the passenger seat. All the way back, I kept seeing Wade beside my father's grave. We had grown up around that cemetery. Before Memorial Day, we mowed the grass together. Before funerals, we raised canvas tents and carried folding chairs through the gate. By the time we were teenagers, we knew which stones leaned after a hard rain. One summer afternoon, we sat beneath the big oak and promised no outsider would ever take the green land. It never occurred to me that one of us might give it away. When my father died, Wade handled the things I could not. He called the funeral home, arranged the cars, and stood beside me while the casket was lowered. "We'll keep this place together," he said. Years later, he helped carry my mother to the same ground. A man who helps bury your parents does not feel like a business partner. He feels like blood, even when the family tree calls him a cousin. We divided the work according to what we did best. I restored stones, cleared roots, and kept track of the families who still visited. Wade handled insurance, taxes, contractors, and paperwork that made my eyes ache after 10 minutes. He also paid bills when other relatives were slow to answer. After storms, he covered fence repairs. If an insurance premium came due, he sometimes paid it before asking for reimbursement. His construction company employed 18 people. Wade never let the family forget that those workers had mortgages, children, and bills of their own. At reunions, he carried a spreadsheet showing what he had spent on the property. The last total I remembered was close to $186,000 over 12 years. Some relatives treated that number like proof that Wade had earned more authority than the rest of us. I never agreed. I understood why they listened. In September of 2021, a storm dropped 2 pines across the eastern fence and damaged the records shed. I signed a resolution giving Wade limited authority to handle the insurance claim, hire contractors, order maintenance surveys, and access property records. That document did not allow him to sell the land. It did not allow him to change the cemetery's use. And it certainly did not allow him to move the dead. At the kitchen table, I opened our LLC operating agreement and found the voting section. A development option required at least a 2/3 vote. Wade owned 35%. Aunt Lydia owned 25%. Together, they had 60%. Not enough. That was when I stopped thinking only like a son protecting his parents. I started thinking like an owner. The file had to show another owner's vote. From the kitchen, I could see one corner of an old banker's box beneath my garage workbench. I had not opened it in years. There was also an email chain from 2013. I had avoided searching for it, although I knew it was still somewhere in my account. My daughter Naomi would have said avoiding a record did not change what it contained. Years earlier, she had asked about the shallow depressions and rough stones along the cemetery's western edge. I gave her an answer that ended the conversation without answering the question. After that, something between us never quite returned to normal. My eyes moved from the box in the garage to Clara's impossible signature on the table. Wade had helped bury both my parents. He had paid bills the rest of us ignored. 18 employees depended on his company. Those were reasons to be careful. They were not reasons to look away. Before saying his name in public, I needed to know whose vote had carried him past 60%. More important, I needed to know whether that person had ever agreed at all. The first name I checked was Clara's. I called her daughter, Monica Fields, the next morning. When I explained what I had found, the line went quiet. My mother signed what? A consent form to relocate graves. That's not possible, Sam. I know. Before we hung up, Monica emailed Clara's death certificate. December 14th, 2023. 14 months before the date beside her signature. She also sent a statement confirming that Clara had never discussed moving anyone from the cemetery. Now I had evidence that did not depend on my memory. The next name was Olivia Greene Cooper. Olivia lived in Charlotte and owned 10% of the LLC. Wade and Lydia had 60% between them. Olivia's vote was exactly what the development file needed to show 70. I sent her a photograph of the resolution. She called back minutes later. I didn't sign this. You're sure? I spent 30 years reviewing insurance records. I know my own signature. She asked me to enlarge the page. A few seconds passed. I know where they got it, she said. The signature matched one she had used on an old property insurance form. Same long tail on the O. Same break between Greene and Cooper. A wrong date could be called carelessness. A dead woman's name could be dismissed as a clerical mistake. Olivia's signature was different. Someone had copied it and placed it where a vote was needed. I returned to the county office and asked for the notice file. The letter supposedly sent to me had gone to a post office box I stopped using years earlier. The meeting minutes listed me as having no stated objection. No one had called, emailed, or sent anything to Greene Stone and Grounds. On paper, my silence had been turned into support. That afternoon, I spread my maintenance photographs across the dining room table. Wade's 26 grave map went beside them. Row by row, the differences became clear. 3 faded stones were missing. 2 family plots had been compressed into one symbol. The whole western edge had disappeared. I had photographed that area after storms for years. The pictures showed shallow depressions, remains of an old fence line, and rough stones set at intervals too regular to be random. Wade's map called them landscape rocks. I read those words more than once. That was the kind of language people use when they want an uncomfortable place to sound harmless. The family notices used the same language. Instead of saying graves would be moved, they promised family memorial improvements and consolidation of burial areas. A relative could sign that without ever picturing a shovel entering the ground. Then I returned to the site plan. C7 crossed the highest strip between the cemetery and the public road. A note along the northern boundary mentioned wetlands and limited access. I did not yet know exactly what C7 was meant to become. Still, roads, drainage, and high ground are not drawn by accident. If the north side could not carry traffic, the line beside my mother's grave might not be one route among several. It might be the route the whole project depended on. By then, 3 problems were connected: false consent, a reduced cemetery map, and a survey line nobody had explained. I stopped treating them like a family disagreement. I sent written requests to Margaret Ellis, New Hope, and the Register of Deeds. Then I called Evelyn Hart, an attorney who handled civil and land use disputes. "I'm not ready to accuse my cousin of anything I can't prove," I told her, "but someone built an $8 million deal on signatures that don't belong there." Evelyn paused before answering. "Then don't call him yet. Start preserving the record." That was the first advice I had received that sounded like a plan. By the end of the day, my photographs were copied onto a separate drive. The county file was locked in my office. Every request had been sent in writing. Wade still did not know how much I had found. I intended to keep it that way until the paperwork began answering questions he could not explain away. Evelyn's first rule: put everything in writing. So I did. Margaret Ellis called 2 days later. Her name appeared as the notary on several consent forms. "I don't recognize these," she said. "You didn't notarize them?" "I'm not making a formal statement yet. I need to compare them with my older files." Clean copies went to her that afternoon. Margaret promised to respond after checking the documents. Not proof yet. Still, one more person was questioning Wade's paperwork. Reverend Elaine Brooks from New Hope called next. She remembered old burial registers that referred to green ground, but the church archives had been moved more than once. "There are boxes nobody has opened in years," she told me. "Give me a few weeks." At the Register of Deeds, I requested certified copies of the 1958 deed and every later plat tied to the property. I wanted to see the cemetery boundaries, the access rights, and any language Wade hoped no one would read closely. Then I made my mistake. Aunt Lydia was 76. She owned 25% of the LLC and had been talking with Wade. The thought of him putting another paper in front of her kept bothering me. I called that evening. "Lydia, don't sign anything else." She went quiet. "What are you talking about?" I found Clara's signature on a consent form dated after she died. Her breath caught. "Wade wouldn't do that. I'm telling you what's in the file." I should have stopped there. Instead, I told her Olivia had denied signing too. Lydia said she needed to sit down. Then she called Wade. I learned that the next morning. A new padlock hung from the record shed door. My key no longer fit. A notice taped to the wood said the records had been moved for document preservation and mold remediation. The shed did have moisture damage. That made the explanation just believable enough. Daniel Rusk did not answer my call. An hour later, Harbor Point emailed me that all future communication had to go through its client. Wade had closed the doors before I could secure what was behind them. That afternoon, a letter arrived from his attorney. It warned me not to remove survey stakes, interfere with contractors, or present myself as the property's sole manager. Wade also started calling relatives. By dinner, 2 cousins had left messages asking why I was trying to destroy an $8 million opportunity for the family. The letter went straight to Evelyn. "He knows," I said. "Yes." I gave him the warning. "You gave Lydia the warning," she said. She gave it to him. Over the next 2 weeks, Evelyn filed a civil case in the Charleston County Court of Common Pleas. We sought access to the LLC records. We challenged the resolution. We raised Wade's private conflicts and the limits of his authority as managing member. At the emergency hearing, Wade's lawyer called the dispute premature. No grave had been touched, he said. No final sale had taken place. Evelyn stood and answered him. That is why we are here before the damage becomes irreversible. The judge did not cancel the development option. The court did prohibit excavation, removal of headstones, and destruction of records. Charleston County separately paused ground-disturbing work while the objections were reviewed. It was not a victory. It was time. Naomi drove down from Atlanta 3 days later. She did not hug me. Her first request was to see the Western Row. We walked through the cemetery while she photographed the rough stones, shallow depressions, and remains of the old fence line. Near one nameless stone, she crouched and looked up at me. You told me these were drainage markers. I remember. That wasn't what I asked. My eyes moved toward the locked records shed. Naomi stood and brushed the dirt from her hands. Wade is hiding something, she said, but so are you. For the first time since the stakes appeared, I understood what stopping Wade might cost. The land was not the only thing at risk. Sooner or later, I would have to answer the question my daughter had been asking for years. Naomi's words stayed between us all the way home. The next morning, Evelyn called. The certified deed had arrived. I met her at the office in Charleston. The document was dated 1958. It described the cemetery as a separate 2.7-acre tract and identified a 40-foot access corridor. Another clause referred to an interest held by New Hope if the land ever stopped being used for burials. I read that paragraph 3 times. Does this stop the project? Not by itself, Evelyn said. It supports keeping things as they are while we investigate the title. 2 days later, Reverend Brooks called from the church archives. We found the right boxes. Naomi came with me. The burial registers were cloth-bound and soft around the edges. Entries ran from 1928 through 1954. Several names were followed by the words West Line or Green Ground. Naomi read them aloud, one at a time. Some surnames were familiar. Others belonged to families no one in mind talked about anymore. Then she looked at me. You've seen something like this before. It was not a question. That evening, I carried the banker's box from beneath my garage workbench into the kitchen. Denise sat at the table. Naomi stood near the counter with her arms crossed. Inside was a hand-drawn map, several burial receipts, and a folded note in my grandfather's handwriting. Naomi opened it. Do not include the West Row on the family map. The room stayed quiet. Then I told them. In 2013, I had found those records while cleaning out an old cabinet. I scanned the important pages and sent them to Wade because I wanted to know if they were real. After that, I asked him to keep them quiet. For years, I told myself I had protected the family from shame. The truth was simpler. I had protected the version of the family I wanted to believe. Naomi's face changed, although her voice stayed level. You knew there might be people buried there without names. I suspected it. For 12 years. Yes. She looked down at the receipts. I'll help them, she said. I'm not promising to help you feel better about yourself. The next morning, Evelyn came to the house and heard the whole story. She photographed the box where it had been stored, sealed it, and wrote down its condition. It remained in my garage under that seal, but I could no longer open or move it without creating a record. If Wade releases those emails first, she said, he gets to tell everyone why you stayed quiet. Under the court order, an independent preservation firm entered the property for a non-invasive ground-penetrating radar survey. The technicians documented the rough stones, the old fence foundation, and every recognizable burial location without disturbing the soil. For 2 days, I followed behind them and watched colored lines build across their screens. The final report listed 43 clearly marked or physically recognizable graves. It also identified 8 rough stone locations and 18 to 24 anomalies consistent with possible grave shafts. The report did not claim to identify human remains. It did not attach names to those anomalies. What it did was make Wade's 26-grave map impossible to defend as complete. Charleston County extended the pause on all ground-disturbing activity. For the first time, I let myself believe we might stop the project before anyone was moved. That hope lasted less than a day. My phone began ringing before 7 the next morning. Wade had released the 2013 email chain. He sent my messages, the scanned records, and my request for silence to relatives, reporters, and Palmetto's attorneys. By noon, the question was no longer only whether Wade had used false signatures and a reduced map. People wanted to know why Samuel Greene had waited 12 years and spoken only after stakes appeared beside his own mother. Naomi stood across the kitchen reading one of the articles on her phone. I did not ask what it said. The emails were real. That was what made them so dangerous. Wade did not hide from the emails. He turned them into his defense. Within a day, he was telling relatives and reporters that both of us had known the cemetery records were incomplete. The difference, he said, was that he had tried to create enough money to repair the cemetery and help the living. It was not the whole truth. It was an argument people could understand. Palmetto Crest released a careful statement. The company called the matter a dispute among co-owners and kept the development option alive. According to them, the invalid consent forms could be replaced with valid signatures. Clara's death certificate had not stopped the deal. Neither had Olivia's denial. Aunt Lydia called after reading Wade's statement. You both kept things from me. Wade used signatures that were not his to use. And you kept burial records in a box. I told her the two things were not equal. No, she said. They're both reasons I don't trust either of you. She withdrew her support from Wade. She did not give it to me. Her 25% was no longer part of either man's plan. The next loss came through my shop. 3 descendants whose family names appeared in the New Hope registers walked into Greene Stone and Grounds. One woman laid a copy of a burial entry on my workbench. This may be my great-grandfather, she said. Did you have records with his name? I told her I had found related documents in 2013. For 12 years? Yes. She looked around at the headstones waiting for repair. You made a living helping families remember their dead. There was no shouting. That made her next words harder to hear. Not every family. After they left, Naomi packed a small bag. I'm staying with a friend, she told us. You don't have to leave. I do, if both of you are going to use me. I never asked you to defend me. You didn't have to. People saw me beside you and assumed I believed you were the honest one. Her hand stayed on the doorknob. I'm helping the people in those records. I'm not helping either Greene man protect his reputation. Then she left. Wade's lawyers made their next move. They asked the court to narrow the temporary order so Palmetto could continue non-invasive traffic, soil, and drainage studies. No excavation was allowed near the graves. Planning work could continue outside the protected ground. The project was still alive. A few days later, the Charleston Preservation Foundation suspended a major contract with my company. They wanted my role in hiding the Western Row records reviewed before giving me more work. The suspension emptied weeks from my calendar. Legal bills kept arriving. Wade called a family meeting at Lydia's house. He brought the old expense spreadsheet, nearly $186,000 for insurance, storm repairs, fencing, and maintenance over 12 years. 2 foremen from his construction company came with him. 18 people work for me, Wade said. They have mortgages and children. If this deal fails, Samuel won't be the only person paying for it. Several relatives looked at me instead of him. After the meeting, Wade asked me to stay. His attorney remained in the room. Through counsel, he made an offer. My parents' graves would remain in place. I would receive $300,000 at closing if I ended my opposition. The money would come from a $425,000 fee Wade's company expected if the relocation was approved. At home, I told Denise. Your parents stay, she said. You get $300,000. Lydia gets money for care. Wade keeps his company. And the others are moved. Denise nodded. In 2013, you kept quiet because the truth cost too much. What would be different now? There was no answer. The next morning, I told Evelyn to reject the offer in writing. Wade had damaged my standing. my business, and my family. What he still expected to own was my silence. That was the one thing I would not sell. Rejecting Wade's offer left me with one more decision. If I meant what I had said, the records could not stay under my control. I carried the sealed banker's box into Evelyn's office. Her staff photographed the container, numbered every item, and created a written inventory while I watched. The originals were placed with an independent records custodian. Authenticated scans went through the case to New Hope and the descendant representatives. For 12 years, I had decided who was allowed to see those pages. That ended when I signed the custody receipt. Naomi still had not come home, but she continued working with Reverend Brooks in the church archives. Together, they compared the New Hope registers with my grandfather's map, the burial receipts, and the radar report. 14 names appeared in both sets of records. 9 dated burial entries also corresponded with rows of radar anomalies along the western side. Those matches did not identify every grave. Reverend Brooks was careful about that. "We can say the records correspond," she told me. "We cannot claim certainty about each person's exact resting place." That kind of restraint mattered. Our family had already caused enough damage by claiming more than the record could support. Margaret Ellis completed her review next. In a sworn statement, she said she had never met Clara, Olivia, or the other relatives listed as appearing before her. The notary certificate carrying Margaret's name matched one copied from a document she had completed in 2021. Olivia filed her own statement. She supplied real signature samples and calendar records showing she had been in Charlotte on the date the resolution placed her in South Carolina. Because the county hearing was already scheduled, the judge let us demand a narrow set of records on an accelerated schedule. Those records included the LLC resolution, survey maps, Wade's consulting agreement, and financial transactions tied directly to the project. The order did not give us everything. It gave us enough. Harbor Point produced its project files under subpoena. Daniel Rusk did not hand them to me personally. I understood why. He was protecting his license and following the court order. The records Harbor Point produced included the 1989 cemetery map, Wade's digital file, its version history, and the transmission emails. Evelyn placed the two maps side by side. The western row appeared on the older version. It had been removed before Harbor Point received Wade's file. C7 had then been designed from a control point taken from that altered map. Daniel had surveyed what he was given. The problem began before his crew reached the property. Until then, I had assumed Palmetto and every contractor involved knew exactly what Wade was doing. The records suggested something more calculated. Wade had given each person only the part of the story he needed that person to believe. I called Lydia and asked exactly how Wade had persuaded her to support the option. At first, she mentioned the projected family payments and her long-term care. Then she remembered something else. He said money had already been released, she told me. He said the family would have to repay it if the project stopped. For the family? That's what I thought. Palmetto's records answered that question. The company had paid Wade Greene Construction $75,000 as an initial consulting fee. Within 3 weeks, roughly $62,000 had gone to overdue vendors and a bank loan. The agreement promised another $425,000 if the relocation was approved. Wade's company would also receive a 3% project interest and a future site preparation contract. He had built a private rescue plan for his business inside the family's land deal. The title report held one more surprise. Palmetto knew there was a cemetery exception in the property records. The company believed Wade's map was accurate. C7 sat outside the protected corridor, and lawful relocation would clear the remaining restrictions. For weeks I had believed the developer knew the full scheme. The documents showed Palmetto had another argument. It could say it had relied on Wade. The preliminary court hearing lasted less than an hour. It cost me more than any full day I had spent in a cemetery. Evelyn asked the judge to declare the development option invalid before the county hearing. The signatures were unreliable. Wade had exceeded his authority. The cemetery records raised questions no responsible buyer could ignore. Wade's lawyer said those issues still required a full determination. The judge agreed. The court would not void the option at that stage. The signatures, the limits of Wade's management authority, and the meaning of the 1958 deed all needed more examination. His attorney also challenged several copies from my banker's box. Where had the originals come from before I found them in 2013? Who had handled them during the 12 years they sat in my garage? Evelyn had sealed the box in May, but that could not establish its earlier history. The judge did not call the documents false. The disputed copies simply could not support immediate relief until their origin and chain of custody were established. That difference mattered in court. Walking outside, it felt like losing. The order against excavation remained. No grave could be opened, no headstone could be moved, no record could be destroyed. Palmetto was still allowed to continue non-invasive planning. Traffic counts resumed. Surface soil studies continued outside the protected areas. Engineers reviewed drainage. Meanwhile, Wade told relatives the court had rejected my accusations. It had not. Charleston County also refused to postpone the public hearing for several more months. The notice process was already moving forward, a county attorney explained. No excavation or disinterment had yet been approved. We review the application before us, he said. The civil court handles the ownership dispute. We were fighting on two tracks with different rules. A week later, Greene Heritage Land, LLC, received another notice. The preliminary survey agreement Wade signed fell within the limited authority I had given him in 2021. If the family improperly terminated the option, Palmetto could seek up to $85,000 in survey and planning costs. At the kitchen table, I read the number to Denise. She looked at the legal bills beside it. We don't have that kind of money sitting around. No, the preservation contract was not coming back. Work at Greenstone and Grounds slowed enough that I started taking money from my retirement account to cover expenses. Denise did not complain. That made every withdrawal harder. Naomi still worked with Reverend Brooks. When Evelyn asked whether she would speak at the county hearing about my stewardship of the cemetery, Naomi refused. I can explain the records, she told me. I can't tell people you've always been truthful about that ground. I understand. This time I did. Wade used every setback. He told the family Palmetto needed only valid signatures and a few adjustments to the grave locations. Several relatives started saying the court had proven the project was legal. The court had done no such thing. Still, I finally understood something. Outrage would not defeat Wade. My reputation would not defeat him. One dramatic document would not defeat him. So I covered one wall of Evelyn's conference room with 5 headings. Authority. Signatures. Grave count. Money. Access. Every piece of evidence had to answer one of those questions. The first 4 already showed a pattern. The 5th remained uncertain. At my request, Evelyn hired an independent title examiner. She traced the 1958 deed through a 1974 road widening plat and a 1992 utility easement. Late one afternoon, she placed those records beside the 2025 plan. Her finger moved between geographic references Wade's map had not shown correctly. I'm not ready to state the final conclusion, she said, but these landmarks do not line up. For the first time since the judge refused our request, the case moved again. We had failed to kill the option with the documents Wade expected us to use. Now we were rebuilding the boundary he had expected no one to find. The public hearing took place on September 18, 2025. By the time I entered the Charleston County hearing room, every seat was taken. Wade sat with his attorney and several relatives. Reverend Brooks was with members of New Hope. Descendants filled 2 rows behind Naomi. Palmetto Crest had its own table with Grant Mercer and company counsel. Reporters stood along the back wall. Evelyn asked me one last question. Do you understand what you're about to do? I do. When my name was called, I did not begin with Wade. I began with myself. In 2013, I had found the Western Row records. I scanned them, sent copies to Wade, and asked him to keep them quiet. The panel heard that I had lied to my daughter. They heard that I had protected my family's reputation instead of protecting every person buried on that land. Once it was in the record, Wade could no longer use it as a surprise. He used it anyway. Samuel knew, he said. The difference is that I tried to create money for a memorial, elder care, and 18 local jobs. Then he reminded the panel that the project could bring the family up to $8.1 million. Evelyn submitted Clara's death certificate, Monica's statement, Olivia's sworn denial, and Margaret Ellis's statement. The current consent packet could not be trusted. Wade's attorney did not defend the signatures. He called them correctable. "We can collect lawful consent," he said. "A defective packet does not make the project impossible." The hearing chair agreed that invalid signatures could defeat the current application without ending every possible development plan. For a moment, Wade looked relieved. Then Daniel Rusk took the microphone. Harbor Point had relied on the digital map Wade supplied. The 1989 map showed the western row. The version sent to the surveyors did not. Daniel displayed the two files side by side. He also confirmed that C7 was the only entrance designed to carry the traffic required for Palmetto's proposed housing density. Wade's attorney said the entrance could be moved. Reverend Brooks spoke next. She presented the New Hope registers and confirmed the church had never released its access rights. It had never abandoned the interest described in the 1958 deed. Grant Mercer acknowledged that Palmetto knew the title contained a cemetery exception. The company had been told C7 lay outside the 40-foot corridor. It also believed another entrance could be designed if necessary. The county had received the title examiner's sworn report and 4-map overlay before the hearing. Wade's lawyers had received them too. When Evelyn introduced the materials, Naomi operated the display because she had helped organize the historical records. She did not speak about my character. The overlay combined the 1958 deed, the 1974 road widening plat, the 1992 utility easement, and the 2025 C7 plan. The older road centerline and utility references aligned. Wade's boundary did not. C7 crossed the protected 40-foot corridor. So did the proposed stormwater detention area. The only alternate route crossed the northern wetlands. At Palmetto's proposed density, it could not support the required road and drainage system. New signatures could not fix that. Moving graves would not create the access Palmetto had been promised. The chair called a recess. Grant and his attorney stepped aside to make calls. Wade tried to approach them, but Grant's lawyer stopped him. 20 minutes later, everyone returned. Grant took the microphone. "Based on the access and title information presented today, Palmetto Crest is withdrawing its option." The room went quiet. Charleston County rejected the current relocation and development applications. The chair made one thing clear. Questions about fraud, damages, and Wade's duties as manager still belonged in the civil case. This was an administrative hearing, not a criminal trial. Wade was neither convicted nor arrested that day. The project was simply over. Across the room sat the man who had helped carry my mother to her grave. Wade had not only promised to move the dead, he had promised to sell a road our family had no legal right to erase. The protective order stayed in place. No headstone moved, and no ground was opened. The western section was fenced for further investigation, while the civil case continued. Within weeks, Lydia, Olivia, and I voted to suspend Wade as managing member. Our combined ownership totaled 65%. Wade was excluded from that decision because his personal interests conflicted with the LLC's. He still owned 35% of Greene heritage land. What he lost was control. No more contracts signed alone. No more unsupervised access to the records. No more speaking for the cemetery as if the rest of us had agreed. By the end of 2025, the civil claims ended in a negotiated settlement. Wade did not admit every allegation. Under that agreement, the LLC granted a conservation easement over the 2.7-acre burial ground and the 40-foot access corridor. The land remained titled to the LLC. The Preservation Trust gained the legal power to prevent the cemetery from being relocated, developed, or remapped by one person. New Hope, the Greene family, identified descendants, and an independent preservation specialist all received representation. I did not receive final control. That was the point. The remaining 14.9 acres stayed with the LLC for possible limited use someday. Palmetto's plan, and the C7 entrance, was finished. The family never received the $8.1 million. Instead, the LLC agreed to pay $42,500 toward documented survey costs. Legal bills still had to be covered, and preservation money had to be raised a little at a time. Palmetto absorbed the rest of its planning losses and pursued repayment from Wade's company. Wade lost the $425,000 approval fee, the 3% project interest, and the site preparation contract. He also had to repay the $75,000 consulting payment. Creditors enforced his personal guarantees. Wade sold equipment and other company assets. Eventually, 11 of his 18 employees lost their jobs. I took no satisfaction in that. Those men had not altered the map. Wade and I stopped speaking. Months later, an envelope arrived with another copy of his expense spreadsheet. There was no apology or note inside. He still believed the years he spent carrying those bills explained what he had done. Maybe they explained part of it. They did not excuse it. Lydia remained angry with both of us. She lost the money she hoped would keep her from becoming a burden. She later supported the Preservation Trust without pretending the family had healed. Olivia kept her ownership interest and helped rewrite the LLC rules. Major decisions now required multiple signatures, disclosure of private interests, and independent storage of maps and records. Harbor Point corrected its files, tightened its map verification procedures, and was not treated as part of Wade's scheme. Denise stayed with me and made sure I never used Wade's betrayal to excuse my silence. Naomi returned to her museum work in Atlanta. She stayed involved as an educational advisor and helped catalog the names we could recover. About 6 months later, she called to discuss a preservation grant. Before hanging up, she said, "I trust what you're doing now." She did not say she trusted me as before. I did not ask her to. Greenstone and Grounds survived at a smaller size. I sold equipment, lost part of my retirement savings, and watched several clients leave. Later, a few preservation groups hired me because our records were managed openly, not because they thought I was a hero. In March of 2026, we held a memorial ceremony at the cemetery. Descendants whose families had been left off the map took the speaking place. I sat beside Denise and listened beneath a new sign. Names still being recovered, resting places protected. For years, I said I had been waiting for the right time to tell the truth. I know better now. I stayed quiet because I was afraid of the price. Telling the truth did not restore every name, repair every relationship, or return the years I wasted. It gave us a chance to stop doing more harm. If stories about family secrets, hard choices, and the cost of late justice matter to you, subscribe to Bloodline Secrets. Silence can bury more than the dead.